Good morning, Larry. How are you?
I'm well, Glenn. How are you?
I'm doing great. So we can just quickly introduce ourselves. I am Glenn Greenwald from Salon.com, and you are?
I'm Larry Lessig from Harvard University.
Great. So you and I have been spending a great deal of time together this week, virtually speaking. And for those who have been unfortunate or fortunate enough, depending on your perspective, to sort of have been unaware of the interaction that we've had and this series of events that have brought us here, I'll just go ahead and quickly recap that. I guess about a month ago or so, I wrote a piece once Justice Stevens announced that he was retiring from the court. It's titled "The Case Against Elena Kagan," arguing why I thought that Elena Kagan would be a poor pick for the president. And then wrote a subsequent piece called "The Case for Diane Wood," in which I argued why Diane Wood would be an excellent pick. You then responded to those two posts with a post of your own on the Huffington Post, in which you agreed with my assessment of Diane Wood, that she was a great judge and would make a great justice, but disagreeing fairly sharply with my view of Elena Kagan and arguing that Kagan would also be a great pick for the court. And then once the president on Monday announced that Elena Kagan was, in fact, his choice to replace Justice Stevens, you and I both appeared on the Rachel Maddow show. I was first, and you were second. Unfortunately, we didn't appear at the same time, so we didn't engage one another. But we each made our cases separately. And you were second, so you were critical of some of the things I had said. And then the following day, we each, on our respective blogs, sort of continued the discussion. I had addressed some of the points that you had made that I wasn't able to address, and you then responded. And I think we both thought that some of the rhetoric that entered into the discussion was, sort of overheated, maybe a bit personalized, and detracted from what are really the critical, substantive, and interesting issues that are raised by the Kagan nomination that we had wished we had been exclusively focused on. And you and I sort of resolved to return to the discussion, make it more interactive, and in a way that focused on the actual issues in a civil and illuminating way. And yesterday we had a debate on Democracy Now! For about 30 minutes that I think we both agreed accomplished that objective, really explored the issues in a very, civil though passionate way. And now here we are on Blogging Heads to continue the discussion about Kagan, but also a variety of other issues, some related, some unrelated. So is that a pretty accurate version of what has brought us here? And I think you have some thoughts to add to that.
Yeah, I think that's perfectly fair. And I think there is something interesting and important to learn about the fight that we had, because we've been in passionate agreement about a bunch of issues, and we've disagreed about issues, but we've never quite come to the point that we came in this case. And what I thought about this morning was the way in which what each of us said was partly fair and partly unfair. So let me try to characterize that, what I think is fair and unfair in each of what we said, and then you tell me if you think I got it right. What has been a constant theme of what you've been arguing about Elena Kagan, and it's a fair point to make, but I disagree with it, is that her early piece in 2001 about the president's power could be read to suggest that she also shared some of the expansive views of executive power that Bush-Cheney advanced. And you, on Democracy Now!, a month ago, you said something which was particularly extreme in that position, but could be read consistent with it. Here it is, what you said. And I'm showing a little sheet which what you said. But what you said there was, and what little there is to see from her confirmation hearing as Solicitor General and a law review article she wrote in 2001, in which she expressed very robust defenses of executive power, including the power of the president to indefinitely detain anybody around the world as an enemy combatant, based on the Bush-Cheney theory that the entire world is a battlefield and the U.S. is waging a worldwide war. Now, what's unfair in how I read that was to suggest that you were saying that the 2001 article supported the president's indefinite power to indefinitely detain. Because, of course, the 2001 article was written before Bush, before any of this theory about the indefinite power to detain was out there. And so it was unfair to link the two directly like that. And so on Rachel Maddow, what I said, and here's a picture of what I said, I said, now that article was written before George Bush, before 9/11, before George Bush articulated anything about this power. It has nothing to do with the power of the president to detain anybody. The power of the unitary executive that George Bush articulated, this kind of uber power of unitary executive, was nowhere even hinted at in Elena's article, yet Glenn has repeatedly asserted that she is George Bush, and that is flatly wrong. Now, when I said that, what I thought I was saying, which was fair, is that there is no connection between the 2001 article and George Bush's theory, and to repeatedly assert it is just flat wrong. But what I said that was unfair was to suggest that you were saying that the 2001 article was about the power to detain, which would be crazy and idiotic because, in fact, it was written before any of that. So both of these had fair and unfair in it. Now, I think what's interesting, and I think this is the lesson everybody should take, these kinds of shows, like the Rachel Maddow show, especially for me, it was my first time, and I'm, of course, an enormous fan of that show. These are stress-producing events. Even Democracy Now!, which both of us have done many times, is a stress-producing event. It's completely ridiculous to take a transcript from an event like that and read it the way we lawyers read things, as if they were written by 20 lawyers over a period of a month. These are off-the-cuff comments which we need to adopt a principle of charity in interpreting. And I apologize that I didn't adopt that principle of charity in interpreting you, because there is an important debate that we have that doesn't have to be clouded by this craziness about, you not knowing that 2001 was before George Bush's theory. And I think similarly, if you, in listening to what I said, had emphasized the second part, which is really about, this debate that we have, rather than imagining that I was emphasizing the first, we would have had a more productive exchange. So I think it's important to draw that lesson. Totally unfair to read transcripts as if they are written documents carefully crafted. And instead, let's focus on where we really have an important disagreement, because that's what I think the country, or at least people interested in this issue, need to work on. So is that a fair characterization of where we are?
Yeah, absolutely. And, I think the other lesson, too, is that if, in terms of being charitable, I mean, there are people in our political culture who participate in political discourse who kind of prove themselves chronically to be dishonest or to espouse, kind of radical and dangerous ideas. And I would put people like Bill Kristol, for example, in that category. And I think it's not only fine but actually warranted to say that we're not going to just treat every single person with great civility and respect. That civility and respect is something that has to be earned, and people can unearn it by a kind of a record of dishonesty and sort of dangerous radicalism. But I think on the other hand, if you're interacting with somebody who in general you think has kind of displayed honesty and good faith in the past, that if you encounter them doing something that in a particular instance seems just all of a sudden extremely dishonest or outrageous, then I think a charitable approach is something that is warranted, because you should assume that people just generally don't act wildly out of character, and that if you suddenly encounter them doing something bizarrely dishonest that you haven't seen them do before, maybe it's just that it's a byproduct of a misunderstanding. So I think that too is an important lesson. I know I reacted to your comments on the Rachel Maddow show very angrily, and had we gotten together and resolved it, and I guess we were doing that by email as I was in the process of responding, we could have avoided that day's worth of acrimony that brought, unfortunately, as much attention to as our substantive discussion has brought, and
right.
We've acted quickly to remedy that, and I'm glad we did, and look forward to doing it over the next 35 minutes or 40 minutes or so.
Great.
So why don't we start in terms of that with kind of a summary of where we are in the Kagan nomination. I mean, I don't think we should try and replicate, and we probably don't have time to replicate everything that we've been over. There's, there'll be links to what we've written. There'll be links to the Democracy Now! Interview. People can go watch that who haven't seen it and are interested. But why don't we go ahead and summarize the substance of our perspective on first why you think Kagan is such a great choice and why she ought to be confirmed.
Great. So let's start with a specific point that I think is an important disagreement, but it's good to get it clear. So I think Elena has written in her 2001 piece about the president an extraordinarily important piece that progressives should embrace. which is not a piece that articulates or supports the crazy view of the president's power that Bush-Cheney had. And so let's understand what that difference is. The Bush-Cheney theory of the executive, what they call the unitary executive, what I call the uber-unitary executive, says that the president has the power to control the administration, to control everything within the scope of the administration, because the Constitution gives him that power, and Congress can't say no. And so the president, during President Bush, was willing even to suggest that if Congress said that torture was illegal, that in the core executive power that he had, he could disagree. That is a dangerous theory of the executive power. It creates a king that can't be checked by Congress, and I think that should be rejected absolutely and strongly by everybody. But the 2001 article that Elena wrote actually is in a continuum of pieces, one of which was written by Cass Sunstein and me, called The President and the Administration, talking about unitary executive theory. And her theory of the unitary executive is not that the president has, because of the Constitution, an unlimited amount of power to control everything there is in the executive. But she instead was saying, look, because of my experience in the Clinton administration, I can tell you that the way the government is working, it is as if Congress has delegated to the president power to direct in all of these contexts, and that's producing a very powerful executive who in the Clinton administration was eager to actually execute the law effectively and efficiently. But as she explicitly says in that piece, if Congress disagrees, then the matter's over. Congress ultimately controls. But this is a kind of unitary executive by default or by statute, not by the Constitution. Now, I think that's an important and valuable and for progressives theory of the president that we should embrace because it gives us a president who can actually do something, achieve something, but not a dangerous president who can't be checked by Congress. And so the one disagreement that we have that's very important to just map, whether we resolve it or not, is that that theory of the executive does not support, even if in some sense it's producing the same result, at least so long as Congress doesn't say no, it doesn't support the radical view that Bush had. And so I don't think it's fair to taint her or tar her with the kind of craziness of executive power that George Bush had. So that's right. One area of disagreement that I think we can at least map and say, here's where we disagree.
Yeah, and I think it's an interesting issue to discuss and try and clarify because obviously questions of this proper scope of executive authority are both, important political disputes and will be very important questions that will come before the Supreme Court. I think I want to just emphasize that from the very first time I wrote about Kagan in that piece, the case against Elena Kagan, I emphasized that what she was talking about in that 2001 article was, as I put it, many universes away from the Bush-Cheney unitary theory of executive authority that ended up shaping so much of what happened over the last 8 years. But I want to just make a couple points about what you said. One is a general point about executive power, which is, and this is something that I used to try and argue all the time to conservatives during the Bush administration, which was, if you vest power in the executive, it is true that you will get good outcomes when your party is in control of the executive. But when your party is not in control of the executive, when another party is in control of the executive, you will get bad outcomes. And that was one of the tactics that those of us who spent a long time opposing Bush-Cheney civil liberties policies unsuccessfully tried to invoke, which was think about having Hillary Clinton have the power to spy on American citizens without warrants, or to detain them without charges, or to engage in all these other actions without much oversight of any kind. You may be comfortable with George Bush doing it because you trust him and think he'll do it magnanimously, but think about Hillary Clinton or some future liberal Democratic president wielding those powers. And that's how I see the issue of executive power with regard to domestic policy and administrative control as well. What's interesting is that in that 2001 article, Kagan talks about how the effort to expand the executive's control over administrative policy actually began in the Reagan administration, and the reason is that they had the opposite objective as the Clinton White House. The Reagan administration was facing a Congress that was controlled by the Democratic Party for several decades. It was the party of Tip O'Neill, Dan Rostenkowski, and the like, and they actually wanted the Reagan White House to be able to control administrative agencies in order to deregulate, in order to prevent administrative agencies from, as they saw it, interfering in the free market. And those powers were then expanded under the Clinton White House in order to enable Clinton, who faced the Gingrich Congress, to encourage those agencies to take a more active role in regulating and achieving progressive goals. So it's always the case that executive power is sort of a two-edged sword. It is good when wielded by people you like, but not so good when wielded by people you dislike. And I think, the issue about how far she really went is a difficult one to resolve. It's a very esoteric article, and because, as we both acknowledge, she was writing before the Bush-Cheney policies, it didn't really directly address that. You're absolutely right that she said that there are serious constitutional problems that can be raised if the president goes too far with it, if he tries to defy congressional limits. But at least at the time, before Bush and Cheney took over and really wildly expanded that doctrine, what she argued really was on the pro-executive power end of the spectrum as that debate was progressing. That's what Neil Katyal said in a law review article where he responded to Kagan's article, and William West, the Texas A&M professor of administrative law, said this article shows she's clearly a fan of executive power. So it's absolutely wrong to suggest the 2001 article means she would be sympathetic to the Bush uber executive power theory, no checks on the president. That has nothing to do with that theory, and if anything, there are things in there that suggest she would be hostile to it. But it does suggest, I think it's fair to say, that she's generally sympathetic to executive power, even within the context of mainstream Democratic Party politics.
Yeah, that's right. And I think you're also right to point out that there are contexts in which we don't want the executive to have this kind of unbridled discretion. Historically, as you know, because you're a constitutional lawyer, there weren't in the English tradition or the Montesquieu tradition. We didn't think of three branches. We thought of two: the legislative and the executive. And the executive included what we now think of as the judicial power. And the great innovation, one of the great innovations at our founding, was to clearly separate the judicial from the executive. And what that meant was there would be rules which got applied to defend rights or defend liberties or defend property that the executive just couldn't overturn because we had a different executive or he changed his mind. And so I completely agree, especially in areas protecting civil rights. We shouldn't have a system where the executive gets to rewrite what the protections are just because we have a different president in power. But on the other hand, in certain complex regulatory areas, there needs to be some flexibility to update and make the administrative state reflect what the democratic process produces. And as much as I think you and I would fight hard to say that we should keep the progressive regulatory agenda out there, we lose too often. Unfortunately, too often we lose. And I think the other side needs their shot too, at whatever their theory is. But certainly within constraints, and certainly not over every single issue that there is to fight about.
Right. So, to me, this issue illustrates one of the issues that I think remains to be resolved with the Kagan nomination, and there's still time to resolve it and an opportunity to resolve it. It's this 2001 presidential administration law review article that she wrote is definitely a major piece of scholarship. I don't think anybody disputes that. And whether you agree with it or disagree with it, to read it is to know that she's an extremely smart and thoughtful individual with a lot of in-depth understanding of the law, which I also think that no reasonable person, even vehement Kagan critics, can or should dispute. At the same time, it is the case that that's an important area of the law, but it's also a pretty small sliver of the law in terms of the kinds of questions that will be presented before the court. And so when I'm looking at what Kagan's views on executive power are in terms of the contemporary controversies that are likely to come before the Supreme Court, I'm looking at things that have happened subsequent to that article that we both agree that article wasn't fully intended to address because it hadn't happened yet. And what I see is a kind of incomplete and mixed record in that regard that I think is concerning and that I'd like to hear a lot more about with regard to Kagan. And this kind of illustrates where I am with the Kagan nomination in general. On the one hand, you have this 2005 letter that she co-signed along with Harold Coe, a favorite of the left, somebody who a lot of people, including myself, would have been very happy to see appointed to the court, and a couple other deans, that made a very eloquent case against an amendment sponsored by Lindsey Graham to deny Guantanamo detainees the right to have civilian courts review their detention. And that amendment that she opposed ended up being incorporated into the Military Commissions Act, which in turn was then invalidated by the Supreme Court in 2008 by a 5-4 decision. So I look at that letter and I think, well, she clearly is somebody who understands the dangers of vesting the executive with vast and unchecked authority, even in the name of terrorism. Then I look at things like the 2008 Solicitor General confirmation hearing, in which Lindsey Graham walked her through a series of questions that were intended to induce her to consent to essentially his view of the world, which is not exactly the Bush-Cheney view of the world. He's definitely more restrained than that, but still closer to it than he would be to any Democrat, which was – and the thing that she agreed to that has a lot of people concerned is the idea that the president has authority to detain people as enemy combatants, not only where there's armed conflict or where Congress has authorized the use of force, such as in Afghanistan, Iraq, even arguably Pakistan, but essentially in the entire world. The example that he asked her about was detaining someone in the Philippines, where there's no war going on, there's no congressional authorization to use force. And even further than that, to detain people as enemy combatants, not who take up arms against the United States, who engage in terrorist plots, who join the Taliban or fight with al-Qaeda, but even people who are distantly related to terrorism, people accused of lending material support or financing terrorism, that these people too can be held as enemy combatants. And she agreed to both of those propositions. And it's been suggested that all she was doing in that colloquy was saying what the state of the law was, but the reality is that that's not the state of the law. The Supreme Court hasn't said that you can detain people as enemy combatants captured away from a battlefield or who are accused of material support. And that is an actually pretty radical view of the war on terror powers. And the problem for me is that both of these are little snippets. That 2005 letter is very eloquent and very encouraging, but is about one narrow issue. The 2008 colloquy, it's a little unclear exactly what she's saying. She's motivated by a desire to get confirmed. And so for me to know whether or not she should be on the court, and this should be true of people on the left or the right, she should be asked a lot of questions and should answer a lot of questions about her views of the proper scope of executive authority with regard to these questions and a whole litany of other issues that are vitally important but that she's never addressed. That's my concern about the Kagan nomination and what I want to see at the confirmation hearings. What's your view of her obligations in that regard to sort of fill in some of those gaps?
Well, so first of all, on the substance, I agree this is an extremely important area to get clear. My own sense of who she is suggests she's closer to the conception of executive power articulated in the co-letter than she is to the suggestion of the conception of executive power that exchange with Lindsey Graham may have created. My reading of that exchange with Lindsey Graham is a little bit less troubling than yours because the question in the context of 2008 was not a question of the president against Congress. Whether we like it or not, Congress and the president had gotten together in substantive ways in supporting this war on terror. So, as you know, there's a very famous conception of how we think about the relationship between executive power and the courts that Justice Jackson articulated in the Youngstown case. And what he said was, when the executive and the president, and when the executive and Congress act in unison, then that's the maximum power of the government. And there's very little scope for courts to question what they do. When they act against each other, where the Congress says one thing and the president says another thing, then it's the court's job to come in and resolve the issue pretty aggressively. And then he also had a twilight zone where it wasn't really clear whether they were conflicting or agreeing, where, again, the courts would need to look at it, but maybe look at it with a little bit more deference. What I understood her to be saying in her exchange with Lindsey Graham is that in the context of the current embrace by both the Congress and the president of this expansive conception of the war, this would be consistent with government's power in general. I think the important question, and you fairly raised it, and I do hope that we get that clarified in the hearings, is what if the president wants to act beyond what Congress says he can do? So, for example, imagine the Congress, this is wishful thinking, this is progressive wishful thinking, but just imagine for a second. Imagine that Congress said, we do not authorize the president to, in fact, we forbid the president to hold as an enemy combatant anybody except in the context of an actual conflict or in countries where there is an actual conflict. So that means Afghanistan and Iraq, that's one thing, but the Philippines, that's another thing. If Congress said that, then there's a question that, which is whether the president can nonetheless act against the statute of Congress. Now, my view is, Elena's answer to that question is no. The president is constrained by Congress in this context just as he's constrained in the other context. That's not to say the constraint is the same. This is a little bit too geeky to get into exactly what the difference between these Article II powers and other powers might be, but he is constrained in both contexts. And so if Congress speaks against the president, then the president's going to have to respect Congress so long as Congress hasn't overstepped its own powers. But I agree, given that exchange, that's an open question in the minds of many, and I do hope, to get back to the precise question you presented, I do hope that she's given the opportunity to answer those questions more fully than that testimony suggests right now.
Right. And of course, we had an example, or a few examples actually, in the last decade where the president did assert exactly that power. We had a statute that said it shall be a felony to eavesdrop on Americans without warrants, and of course the Bush White House said they nonetheless had that power under Article 2 to disregard the congressional statute. I think there's a real question as to whether or not Congress has actually authorized people outside of war zones and engaged in material support to be held as enemy combatants. I don't think it's clear at all that the Congress has gotten together with the executive and authorized that. And of course, even as you acknowledge, where the Congress and the executive branch get together, there's still a role for the courts, which is to say whether what they've agreed to is actually constitutional, and so that's something that probably would come before the court. But to me, it's what's really interesting, and this probably should be the last thing on Kagan, unless you have other things. I mean, to talk about this issue as the last issue on Kagan is it's funny when she did get when Obama did announce her nomination, and even before that, when I was writing about her, the thing that she had written that I actually thought that I was most enthusiastic about was the 1995 book review, where she essentially lambasted the confirmation process and called it a vapid and hollow charade, and said that senators ought to be embarrassed at their willingness to confirm people to the Supreme Court without getting specific answers to real questions about what the nominees' views of the law are and determine how they would be on the court. To me, that I'm actually keeping an open mind on the Kagan nomination for or against, even though I was against her and hoping the president wouldn't choose her, pending the confirmation process. But I think, and this is the point I intend to emphasize as much as possible between now and then, to put somebody on the Supreme Court, especially a very closely divided Supreme Court, for what is likely to be the next 30 to 40 years, which is how long she'd likely serve given her age, is an extremely consequential step. I mean, that is a lot of power to vest in a single person. I mean, she could easily be the swing vote in lots of very crucial cases that shape what our political system is. And in fact, that's the argument in favor of her, that she will be doing that. And so I just think that it's incumbent upon all of us, no matter where we fall on the political spectrum, not to form an opinion about whether she should be on the court until we actually have insight into how she thinks and reasons and believes beyond what we have now, and to demand of senators and of her that the standard that she so persuasively articulated that should govern confirmation hearings prevail, and that she tell us what her views are about some of these past cases where she would have come down, how she sees the Constitution and some of these issues. Obviously, she can't talk about and shouldn't talk about how she'll vote on cases that are likely to come before the court, but I really think that this process needs to entail a lot more specificity than it has in the past, and if that happens, then I may reconsider my view of Kagan, and it could create a really good precedent for how we do these things in the future. Do you think that's viable and productive, to expect that to happen?
Well, it's interesting to recognize that piece which Kagan wrote was one of the last pieces she wrote before she was tainted by her experience in government. That was her last pure academic piece. And then she went to work for the Clinton administration. And she began to understand a little bit more completely how Washington actually works. Now, I have never been tainted in that way. You neither. You've never worked for the government.
Right.
So we are likely to be like Kagan in that piece, committed to the principled and perhaps idealistic view that somebody should be able to be completely open about where they stand on all these issues, and that we should be entitled to know, because it's important to know for all the reasons that you've said. But the argument on the other side is this is as much a political game as an intellectual game. And the Republicans have historically been quite aggressive in asserting the very narrow obligation on a nominee to say anything. I clerked for Justice Scalia. Scalia wouldn't even concede that Marbury versus Madison, the important case that established the Supreme Court had the power to strike down laws, was constitutional. He said, "It's not. I'll wait till I hear that case. I'm not gonna prejudge it right now." So they've played a very politically astute game of saying we don't have to say anything. Now, I disagree with that game. I wish everybody would say everything. But one could also say, and I'm sure many of the people inside the Obama administration are saying, why should they get to play the game where they don't have to say anything, but our nominees have to say everything? Because we know that whatever our nominees say, there's going to be something that the other side can grab onto and say, this justifies this justifies us blocking the nomination in the Senate because she has said blah. I come out a little bit more ambivalent about this question. I certainly agree with you and want a world where justices or nominees to the Supreme Court are as honest and complete as they can be. But I also recognize we live in a world where some of the very best potential Supreme Court justices simply could never have been nominated because we know the way the system would chew them up. So on the right, Judge Richard Posner, who is perhaps the most brilliant of that whole side of the aisle, one of the most productive judges in the history of the United States, and certainly one of those productive scholars, everybody knew he could never possibly be nominated because the system would tear him up, because Democrats would take whatever he had said out of context and make it seem crazy. I think the Democrats think the same thing about Democratic nominees. And I guess, one of the problems here is we need to recognize our political system is pretty broken if it can't take these serious issues on seriously. But that's the reality. And so I can understand the call that says, we're going to play this the way the Republicans played this. We're going to be as narrow about it as possible. And Professor Kagan may have had a view about what would be great policy, but Professor Kagan is not nominee Kagan, and nominee Kagan has to live with the realities of this very broken political system.
Yeah, no, I think that's true, and all the things you just said are true. At the same time, until someone steps up and starts changing things don't get changed. And I think the other side of it is, you look at the last few nominees like John Roberts and Sam Alito, Sonia Sotomayor, even people who are on the court. And I think people had a pretty good idea of generally where they fell on the political spectrum, even though they played this absurd confirmation game of not saying anything meaningful when asked questions. And I think it is different with Kagan. We can and have argued about the extent to which it's fair to call her a blank slate, but it's certainly true that, Tom Goldstein said this, and he's a huge Kagan supporter, a huge, I would say, reverent fan even, that less is known about her than any prospective justice since at least David Souter. And so it's arguable, I think, that in this case there's a more compelling need to have her answer questions with greater specificity than perhaps in the past.
That's true. We know less about her than we've known of any justice since Justice Souter. But we know more about her than we knew about Justice Rehnquist, Justice Powell, Justice White, Justice, I would argue, the second Justice Harlan, Justice Douglas. Maybe you had a pretty clear view of where he was, but he certainly had never sat on a court and written opinions. So one point to keep in mind is that what the president has done is revived, I think, an important tradition of nominating people who are not judges. Probably something like 35 to 40% of the Supreme Court was never a judge before they got to the Supreme Court. And that's valuable because having practical understandings different from a judge helps the court avoid really idiotic decisions. Like, for example, a decision we both agree is idiotic, Citizens United, which had Justice O'Connor been sitting on the court, would never have been decided in that way, because she had a very real sense of how political battles are fought, because she was a politician before she was a judge. So I think that diversity is an important value, but one consequence of that diversity is we will systematically not have as complete a sense of who somebody is as we would have if they had been a judge or if they had been an outspoken academic the way somebody like Pam Karlan is.
Or Larry Lessig is.
Yeah, well, the chances of Larry Lessig being nominated to the Supreme Court are about as great as the chances of world peace in the next year.
Right. And, so that, yeah, I think, that, and it just, that it relates to the same problem, which is, you can obviously have a very substantial written record, without being a judge. Law professors do, politicians do, some of the people who were named as potential, alternatives to Kagan, like Jennifer Granholm or Janet Napolitano, Pam Karlan, Harold Koh, all have very much more extensive records to know what they think than Kagan has. You can have an extensive written record, but perhaps the reason they didn't get chosen is precisely because of that record, right? And exactly so, right. The problem goes a little bit even deeper. So, okay, great. So if you're good with that, why don't we shift focus, we don't have a huge amount of time, but we do have some, to a topic that is near and dear to my heart and to yours, which is the problem of corruption in Congress, by which I mean that our legislative process is essentially shaped and governed primarily, if not almost exclusively, by the powerful vested interests that basically own the Congress through their campaign money and other ways of controlling the process. You referenced Citizens United, which gutted one of the ways that at least that those influences had attempted to be at least sort of controlled. Even before Citizens United, you and I both thought that Congress was so radically corrupt. It wasn't as though things were great until Citizens United, but it rolled it back even a little further. You and I actually had some disagreements on Citizens United. I was more sympathetic to the First Amendment arguments the majority cited than you were. But we've debated that case before. So here we are in a post-Citizens United world where a lot of these restrictions on corporate spending have been called into question, and we already had a system where the voice of the average American was almost completely snuffed out of the process. What, if anything, can we do in light of the ruling by the court in Citizens United? You've talked about some proposals. The Democrats in Congress have proposed some things. The White House has proposed some things. How do you see the landscape currently in terms of addressing these problems?
Well, I think first it's important to acknowledge a great failure here. I think many of the progressives are skeptical about Kagan because they see this as a piece with the president not delivering on strongly enough on promises that at least progressives thought he had made about how to change Washington. And I, in particular, have been an outspoken critic of his failure to take up his promise to, quote, change the way Washington works. And what he meant by that, as he explained again and again, and I went back and read every one of his speeches to confirm that, in fact, I wasn't making this up in my head, was that he was going to change the power of special interest to direct policy in Washington. He hasn't taken up that fight. And as he said, if we don't take up that fight, then we're going to be fighting the same issues generation after generation. And I think we're going to see that. That's exactly what's going to happen because in healthcare, he struck a deal with the most powerful interest and got a healthcare bill that didn't change the fundamental problems with our healthcare system. I think we're seeing the same issue in the context of financial reform. Truly the most outrageous sellout to the rich in the context of the deregulation of financial systems, and we still don't have any effective response to that in this legislation. We're going to see the same problem in global warming. Look, the guy's striking a deal to do offshore drilling. After the worst offshore drilling accident in the history of offshore drilling, he's still committed to that deal because that's an essential deal to strike in order to begin to get progress on global warming legislation. Now, I'm not saying that that's stupid strategy. It's just the kind of strategy he said he was going to change, and he hasn't done that. And so I've been very critical of him. And one of the reasons why the White House isn't encouraging me to talk about the Kagan nomination is because I'm, also talking about the failure of the Obama administration in this particular respect. So what do we do after Citizens United? Well, what the White House has supported is, I think, puny legislation. Not that it's not a good legislation. I completely support what Schumer and von Hollen are doing. I think it would be good to have those laws on the books. But they won't begin to address the fundamental problem, which, as you said, was a problem that long predated Citizens United. And Citizens United made it worse but didn't actually create it. And that is the fact that we have an economy of influence in Washington where the way you get elected is to pay exorbitant attention to powerful moneyed interests. If you don't pay attention to those powerful moneyed interests, you don't get the money you need to run, or your party needs to win, and therefore you lose or your party loses. So both parties have become excellent at selling out their soul to these moneyed interests for the purpose of getting the campaign funding they need to run for office. Now, until we change that system, Washington is not going to change. And so I've said the first step we ought to take here, if we're going to fix Congress first, is to get citizen-funded elections. And there, in fact, is a bill right now in Congress called the Fair Elections Now Act, which would make it so members would opt into a system where they accept no more than $100 from any particular citizen. That gets matched 4-1, but what that would produce is a Congress that was no longer desperately dependent upon large special interest contributions, but instead had to raise money the old-fashioned way by going out and trying to convince a whole bunch of small-dollar contributors. Now, I actually have, I think that there are better, stronger solutions than this, but I think this is an essential first step. And what I think the president should have done is taken the opportunity of Citizens United to say, okay, we have a catastrophe on the horizon, and we need to address this problem right now in a fundamental way. And the way to do that is to convince this nation that this change is an essential change to change the way Washington works. But until we do that, I think we're going to have the same problem. Maybe we'll get more progressive laws than we would have gotten under John McCain, but we're certainly going to get nothing like what we need if we're going to address the fundamental problems that this nation faces.
Yeah, I think a lot of times, there in our political debates, lots of people talk about serious problems, and it's really hard to identify the most important issue. I mean, whatever anyone happens to be focused on or cares about most, a lot of times gets depicted as the most important issue. But this really is an overarching problem because it doesn't even matter. It obviates every other aspect of our political system. It almost doesn't matter what the results of elections are. It doesn't matter what the debates are about how laws should proceed. If you have corporations and lobbyists writing the laws across party lines, which is exactly what we have, then that's the system of government that we have. And it's interesting. I picked once the most significant quote of 2009. I was asked about this, and the quote I chose was Dick Durbin gave a interview to a Chicago radio station, and this was in the wake of the financial crisis and the bailout. And what he said was, look, even after everything that's happened, the banks still own this place, meaning Congress, which is an amazing and extraordinary thing for someone like him to say. I mean, he's the number 2 ranking Democrat in the Senate, and he's saying that across party lines, the Democrat and the Republican Party in Congress is owned by the banking industry when it comes to that legislation. And just to underscore your point about Obama, Nation magazine had this forum where they asked a whole variety of commentators and writers to identify the best thing that the Obama administration has done and the worst thing. And I was one of the people who participated. And I know a lot of people thought that I would pick one of the civil liberties abuses as the worst thing because that was my focus, but I didn't. What I chose as the worst thing was, or the low point, that was at the high point and the low point. For me, the low point was when the president got caught secretly negotiating in the White House a deal with the pharmaceutical industry about what the health care bill would be. Because if you go, and that was leaked to the New York Times and the Huffington Post, and they first denied it and then were forced to admit it once the memo was surfaced, because as you were saying, if you go and look at what his campaign was all about, it was far less about specific policies or positions, and much more about changing Washington in a very clear way, which was, we are not going to negotiate laws in secret with special interests who have a stake in the legislation. We're not going to allow secret deals to govern how legislation is shaped. And in the healthcare bill, even if you're someone who thinks it ended up doing more good than harm, that is exactly how that bill was written. I mean, it was written by well-point executives, by secret deals over the public option with the health insurance and pharmaceutical industries. And so the system that he vowed more than anything else to dismantle has continued. And so I actually, along the lines of public financing is the solution, which I favor so vigorously. There's an interesting example that kind of illustrates the power of that, which is Alan Grayson, who's a very controversial figure because of the kind of rhetoric that he uses. He raises a lot of passion, but one of the things that he talks about and has done that I think is really interesting is he's actually avoided taking money from lobbyists and corporations, and he has raised an extraordinary amount of money, I think more than any other freshman in the Congress, strictly by small donor contributions, mostly from the netroots. And so his constituency is not Wall Street or any industry or lobbyist. His constituency really is the netroots, individual citizens who congregate online in order to engage in political activism. And he has talked about how that has created a new template, or can create a new template, that has really freed him up to do things like attack Wall Street mercilessly and to use rhetoric that, even if you don't agree with, is at least the kind of rhetoric that the people who are supporting him, who are citizens, want to hear. Is it possible to kind of create that template without a public financing system, or how do you envision a public financing system really solving this problem? Would members of Congress really be able to turn away from lobbyists and corporate interest and have an equally strong base of support that they could pay attention to instead?
Well, I think Grayson's a great example, but I think it's important to remember this is not something that only Democrats care about. My favorite recent candidate is a guy named Bob Overbeek, who was a Air Force officer who went to serve in Iraq and Afghanistan after 9/11. And he said he went to serve because he thought that the threat to America was a foreign enemy. And then he says, I went to Afghanistan and I met the foreign enemy, and I realized the great threat to America is a domestic enemy. And the domestic enemy he points to is exactly this power of moneyed interests. This is a Republican running in the Michigan 3rd, and he is committed to taking no more than $1 from anybody in his campaign to run for Congress. It's a Buck for Bob campaign. Because, he, like Alan Grayson, like all of us, realized that we might differ in the policies that we advance, but we have a common enemy, and the common enemy is this distorting influence in our democracy that makes it so even when you win, you lose, because if what you want when you win is to change the status quo can always block that change. Now, as you said, it's hard to argue about what the most important problem is. Unfortunately, right now, America faces an extraordinary number of important problems. But I like to think about it in the model of, kind of the alcoholic, which is a good analogy for what's going on in Congress. These guys might be well-meaning, they might really want to do the right thing, but like an alcoholic, they're constantly distracted by this dependency that they have, that they've got to constantly feed. And what we know about the alcoholic, and unfortunately all of us know this, because all of us have in some sense been touched by an alcoholic, whether right in your family or your friends or something, we've all suffered because of the suffering of alcoholics. What we know about the alcoholic is he might be facing enormously important problems. He might be losing his job, his wife, his liver. And those are the most important problems in his life, but we know that until he solves his alcoholism first, he's not going to address any of these other problems either. So it's not that the alcoholism is the most important problem, it's just the first problem. And he's got to solve that first problem first. And so too with our Congress. It's not that campaign finance is in some sense more important than global warming or getting a financial sector that doesn't throw the economy off the cliff every 5 years. But it is the problem we have to solve before we can solve any of these other problems. So I think getting a powerful citizen-funded election bill out there, like the Fair Elections Now Act, would be an important first step. But we need to all be quite realistic about the fact that it's just a first step.
Well, let me ask you about this. One of the things you said, and our time is sort of running out, but I do want to ask you about one of the things you said because I think it's super interesting and important. Our politics are so polarized, of course. That's an obvious fact. And I think it's almost impossible to get broad-based initiatives like serious changes to our political system enacted unless there's truly support across the political spectrum. If it's just a liberal or a leftist view or conservative or rightist view, the chances are very small. I've thought for a long time, for the last year or so, that opposition to how our political system works, namely the control by moneyed elite, is one of the very few issues that truly should and does have cross-ideological appeal. And if you look at, the idea that corporations have excessive influence in our political system has long been a staple on the left in progressive politics. And if you look at the Tea Party movement and some of the anger on the right at things like the bailout of Wall Street, and even the Obama administration's ties to Wall Street as well. Of course, some of that is quite partisan, but a lot of that is also based in the same kind of anger over the perception that our government is basically controlled by a small and narrow elite at the expense of ordinary Americans. Do you see that as the kind of an issue that can transcend right-left differences and kind of have citizens join together across the spectrum to demand changes in a serious way?
Absolutely. The polling that has been done about this demonstrates that Republicans are actually more outraged by the existing system and to a small degree, actually favor reform of the existing system more strongly than Democrats. But both of them are in the 80-plus percentage point. So outside of the Beltway, there is strong bipartisan support for fundamental change the way the system works. But inside the Beltway, nobody in that system can begin to imagine radical change except few people who've tried to push for it, and Durbin is one of them, and Grayson is somebody else. But Republicans too. Walter Jones from North Carolina, made famous because of his freedom fries, is also a very strong supporter of this change. He co-sponsored the bill in the House. But people inside of the Beltway depend upon the system continuing because when they leave Congress, they go become a lobbyist and they get paid 3 or 4 times the amount of money they've made as Congress. Staffers on Capitol Hill work for 6 years in a committee and then go trade that in for extraordinarily lucrative jobs in the lobbyist shops that will pay them because of their access. Now, that economy would radically change if we had public funding. And so that's why the people inside the Beltway fight it. But I think there's a very important political opportunity, an arbitrage opportunity, if the right candidate or the right campaign came along that could credibly say to the nation, look, this is the thing we need to change, whether it's from the right or from the left. This is the thing we need to change if we're going to have a democracy that works. And what that means is when you win, you win. And right now we don't have that democracy. So I think you're absolutely right. It has to be bipartisan or nonpartisan. But I think that the predicate for that is there if we could just find the leader who could grab it and run with it.
Yeah, I agree completely. Unfortunately, these things, what ends up happening is there always seems to be these sort of relatively trivial and very polarizing issues that keep people separated who could come together on very discrete issues, even if they disagree about all kinds of things. And if citizens do come together across party and ideological lines and truly demand change with passion and anger, even the most entrenched interests in Washington at some point will be incapable of resisting that. We just haven't had that yet. But I think you do see signs that we're moving towards that, and I certainly agree that it is the overarching and sort of immediate problem, but without which nothing else can really improve.
Right. So that's very boring. Now we completely agree. I guess that means it must be the end of the.
It's true. We're going to end. We're going to end. We began on a little bit of a harmonious note, examined our disagreement, and now we can end with a little sunshiny thought, which may not be characteristic of either of us, but it's a good little diversion and abandonment of how we usually do things.
Okay. Thank you very much.
Thank you, Larry. Appreciate it.